All right, so I think we can get started. Hello and welcome to this Mayor Brown Cybersecurity Awareness Month webinar, Federal and State Privacy Legislation and Associated Requirements. So today we're going to cover developments in state and federal laws. My name is Arsen Karinian. I'm a Los Angeles-based partner in the firm's cybersecurity and data privacy group. With me is Howard Waltzman, a partner in our public policy, regulatory, and government affairs practice in Washington, D.C. If you're participating in this webinar live, this program will be eligible for CLE credit. You'll find the link to a CLE affirmation form on the email they received with connection information to this webinar. We'll be providing a CLE code during the presentation, which you'll need to enter into the form if you are viewing a recording of this webinar. Unfortunately, the CLE is not available.
Today, Arsen will be taking us through the privacy landscape in the U.S., including the general structure, state activity, and U.S. biometric and AI laws. I'll follow Arsen's discussion with a look at federal privacy legislation, in particular the American Data Privacy and Protection Act, describing its key elements and the issues of contention. We hope to have time at the end of this program to answer some of your questions. You'll find a Q&A button on your screen so that you can submit your inquiry, and we'll try to get to as many of those as we can. So with that, Arsen?
Great, thanks, Howard. So it's a pretty interesting time in the United States when it comes to data privacy laws. A few years ago, we just had one comprehensive privacy law in California, but now we have many. And so today I'm going to give a brief overview of the privacy landscape in the United States and some of the key issues you should be aware about. Next slide. So to start on a very high level, it's important to understand how the US data privacy law landscape is shifting. I think prior to California passing the first comprehensive privacy law, and still what is the case today, on a federal level, privacy is primarily regulated on a sectoral level. So if you're a financial institution, for example, you're governed by the Gramm-Leach-Bliley Act, which delineates the rights and obligations of a financial institution when it comes to certain financial data with its customer or consumers. If you're a covered entity like a doctor or a hospital or a pharmacy, you're subject to HIPAA, and that covers the healthcare privacy laws. On a state level, a lot of it prior to the CCPA was mostly based on common law doctrines and sort of mini federal versions of some of these sectorial laws that existed throughout the states. But the state laws primarily prior to CCPA governed breach notification laws and also various lawsuits under mini UDAP statutes, such as Unfair and Deceptive Practices Act claims. As far as US enforcement of privacy laws, it's a mix of state and federal agencies. So for example, the Federal Trade Commission, the Health and Human Services, at least for HIPAA, and various financial regulators may be involved in enforcing privacy laws on a federal level. And then on the state level, the main enforcement arm are the state AGs, essentially. Next slide. Now, as I mentioned, the US comprehensive privacy law landscape is definitely developing. We initially started with one law in California for comprehensive privacy law, which was the CCPA, and that went into effect on January 1st of 2020. But now we have 4 other states with privacy laws, along with California through a voter proposition passing the California Privacy Rights Act, which also goes into effect on January 1st of 2023. And so a lot of the issues that we often get asked is, how do you harmonize all these laws? How do the requirements of these laws compare with each other? And that's the main thing we're going to cover today during the presentation. Next slide. So to start things off, the California law, along with the other state laws, offer various rights to consumers. So as you can see in this side-by-side comparison, all of the states, California, Utah, Connecticut, Colorado, Virginia, they all extend the right to access or right to know to consumers. So essentially, if they submit a request, you have to produce information about what type of personal information you have about them, why you collected it, who you shared it with, among other details. And you have to share that in a portable manner within 45 days for all of these state laws. The great news is that when these other non-California state laws passed, they implemented similar timelines for responding to various requests. So it definitely helps with implementing a harmonized approach for responding to consumer rights requests throughout the United States. And another right is the right to correct. As you may recall, under the CCPA, there was no right to correct under California's law, but there was an effort to essentially enhance the California's law to make it similar to the GDPR. And there's a real strategic reason here. California is at least striving to get adequacy status from the EU so that data can be sent freely across borders. Now, while it is optimistic, we know that is part of the effort of why the CCPA was in fact enhanced to become the CPRA, and which is why we're also seeing some GDPR elements flow into California's law. But other than California, except for Utah, the other states are also offering a right to correct to consumers. Next, all of the state laws offer a right to delete. So consumers, subject to certain exceptions, can submit a request to essentially have all of their information deleted from the company's records. And as I mentioned, as part of the sort of right to access, consumers can also receive the data that you have about them in a portable manner so that they can freely transfer the data from one business to another, or have it in a manner that they can utilize, read, and understand. Another right that is offered in all of the state laws is the right to opt out of sale. Now, the definition of sale is a bit tricky. It doesn't mean what a layperson would understand it to mean, where essentially if you take 100,000 pieces of information and you sell it to another party for X dollars, that would be like a traditional understanding of what is a sale. But under most of these state laws, including in particular in California, sale is a very broad term, and it includes not only transfer information or making available information to another party for monetary consideration, which is the traditional understanding, but also for other valuable consideration. We saw headlines in the news about this idea of sale in California with the first public enforcement action against Sephora related to its use of cookies and other trackers on its website for targeted advertising. And the California Attorney General's office found that to be a sale because there are not sufficient service provider agreements with these cookie providers. And so when you're thinking about whether you are a seller or not, I would just caution that think about this term very broadly, and it doesn't mean what you might traditionally understand it to mean. And based on your ad tech practices, you might actually end up being a seller under these states' privacy laws. Next, all of these states offer a right for non-discrimination. In other words, if somebody is to exercise their right under these privacy laws, you cannot discriminate against them by changing the quality of the goods or services they are offering, among other things. Another interesting thing about this non-discrimination prong is if you offer any financial incentive programs or loyalty programs in which you're offering a price or service difference to individuals, California has very specific notice and data valuation requirements in order to abide by this non-discrimination clause. And one of it is the requirements is to give a notice explaining how to opt in and how to opt out of the financial incentive program, the terms of the program, what types of categories of information you collect as part of the program, and then also conducting evaluation to see how much is the value of the data worth. And there's different standards you can utilize. And based on recent regulations in Colorado as well, or draft regulations, we see that Colorado is following in California's steps with this requirement of giving notices and conducting a data evaluation for financial incentive programs. And then finally, a couple of the states, Connecticut, Colorado, and Virginia, require you to offer an appeals process whereby if you deny somebody's data subject request, they should have an opportunity to appeal the decision and have it reviewed again internally in the company. Next slide. In addition to data subject rights, the various state laws also have internal independent business obligations that you have to abide by. And so if you recall, I mentioned that these state laws are really starting to look like the GDPR. Some of the elements you see here may resemble Article 5 of the GDPR and others. And so in addition to making sure you extend consumer rights, also ensure that you have internal policies to abide by these separate obligations. So for example, under all of the state laws, except for the predecessor to California's law, the CCPA, you're required to abide by the data privacy principle of data minimization. And what that means is when you're engaging in an activity with a consumer, you only collect the minimum amount of personal information you need to carry out that objective. So for example, if you need your business contacts information, such as a name or email address, but you have no need to collect, for example, their social security number or driver's license number, under the data minimization doctrine, you wouldn't collect those other forms of extra data if you have absolutely no need for it. Also, the states have adopted the purpose limitation doctrine. And what that means is that when you collect somebody's information, you're required to give a privacy notice at or before the point of collection, telling the individual what information you're collecting and why you're collecting it. And you're supposed to only use the data within the scope of the disclosure that you gave and not beyond that. Because if you do, you have to essentially get consent from the user before you use it for other reasons that you did not tell the user about. The state laws also have a requirement to safeguard data. And also there's various obligations related to sensitive data, which is a certain type of data that deserves heightened protection under privacy laws, such as demographic information related to race, ethnicity, religion, or trade union membership, precise geolocation data, and a more expansive definition under California's law, which also includes certain financial information and medical data and biometric data. And so when you're looking at the state laws under Connecticut, Colorado, and Virginia's law, you're required to get opt-in consent before collecting such sensitive information, while Utah requires offering an opt-out when you do collect sensitive data. California is a bit unique. It took a bit of a hybrid approach, which is sort of like an opt-out system. Essentially, under California's law, if you collect sensitive personal information, but you only use it for certain limited purposes that are delineated in the draft CPRA regs, such as to provide a good or service, for fraud detection, for security reasons, among other grounds. You're actually allowed to collect the sensitive information and use it for those limited purposes without even offering an opt-out. However, if you do use sensitive data for other ancillary reasons, you're required to offer to consumers the right to limit the use of their information to those specific list of reasons. All of these state laws also have special requirements when it comes to children's data, and it's primarily tethered to, before you sell children's data, you're required to get opt-in consent, and also opt-in consent is required for a collection of children's data under the age of 13. Is deemed sensitive as well. All of these state laws also have a privacy notice requirement. And again, the good news there is the privacy notice can be harmonized among all the state laws. They do share some common elements, such as explaining what information you collect, why do you collect it, and who do you share it with. California, though, is a bit unique with its privacy notice requirements, unlike the other states, because it also requires you to explain your prior 12-month data collection practices along with your forward-looking privacy notice that you give at or before the point of collection. And so just make sure you factor that in when drafting a privacy notice. And again, all of these other state laws have rights related to sale of data, where you have to offer an opt-out. Also, there's an opt-out right related to targeted advertising as well. Some of these states also offer require preparing a data protection impact assessment, such as in Connecticut, Colorado, and Virginia. and also soon to be developed in California with the second half of the draft regs, which are anticipated to be released. And essentially what this is it's an assessment where you evaluate high-risk processing activities and you determine whether, on balance, the utility of the collection outweighs any risks, and you factor in the mitigation measures you would need to take in order to roll out the program and collect the information. And then finally, under all of these privacy laws, if the data is de-identified, where it's not capable of identifying someone, it does fall outside of the scope of a lot of these requirements. So if you can collect information either in a de-identified form or aggregate form, consider that as an option as well, in order to reduce your data privacy footprint. Next slide. So under US laws, there's also 3 states with very specific biometric laws. The one that causes a lot of concern for a lot of companies is in Illinois. Illinois is the only state with a biometric law where there's a private cause of action. And in a nutshell, with these 3 biometric laws, the critical factor here is getting opt-in consent before you collect biometric information. And so for opt-in consent, it needs to essentially be a just-in-time tailored notice identifying the fact that you're collecting the biometric information, the purpose for collecting it, and how long you plan on keeping the information. You also have to detail a retention period for how long you plan on keeping the biometric data for, and also consider avoiding any type of downstream disclosure of the biometric data under these privacy laws in order to ensure compliance. Especially in Illinois, as I mentioned, it's a hotbed of litigation. There's a lot of BIPA lawsuits there under the biometric law, and there's some significant verdicts that have come down under, and settlements come down under Illinois's BIPA law. So just be very careful in that jurisdiction in particular, and seriously consider whether you really need to collect biometric data in light of this heavy scrutiny. Next slide. Also, as I sort of briefly touched on, in addition to these 3 states with specific biometric laws, biometric data is also now regulated as sensitive data under the comprehensive state laws. So for example, under Colorado, Virginia, and Connecticut's privacy law, and also California and Utah, biometric data is considered sensitive. And there's different obligations you need to abide by if you're collecting this form of data, such as getting opt-in consent in Colorado, Virginia, and Connecticut. In California, as I mentioned, ensuring that you either use the data for certain limited purposes, or if you don't, offering a limit use and disclosure right to consumers. And in Utah, if you do collect biometric information, you do have to offer an opt-out right. But a practical tip here, anytime you're collecting biometric information, regardless of what state you're in, strongly consider getting opt-in consent and providing a short form consent notice every time you collect biometric information because of the risk of liability and because of the sensitivity of this data. Next slide. The US is also now heavily regulating artificial intelligence and automated processing of data. So for example, under California, Virginia, Colorado, and Connecticut's privacy laws, there's now an opt-out right if you're essentially using automated processing tools or profiling to make decisions about someone that could impact their livelihood. The specific definition that is used under these laws is related to an impact to their economic situation or health or personal preferences, interests, reliability, behavior, location, and movements. And if you create a profile like that about someone, if it could have a legal effect on them or other similar effect, you're required to offer an opt-out right. Now, in thinking about this issue, some common examples are if you deny healthcare to someone, if you deny housing or line of credit, essentially things that could have a true impact on someone's life. That said, anytime you use any type of automated tools or profiling, again, I would strongly consider to play it safe and just offer this opt-out right to avoid any risk of regulatory scrutiny. Also, if you do have automated tools, just be aware that President Biden also issued an executive order a couple of weeks ago related to the AI Bill of Rights, where explaining that you should test these tools to make sure for accuracy, to avoid any type of bias or discrimination, and to make sure that it's operating in a transparent and fair manner. In California, the second half of the draft regulations have not yet been released, but California is going to issue regulations governing these automated processing tools and profiling tools that companies use. What we do know from the statute itself, which describes what type of regulations will be released, is that there is going to be some form of an opt-out right, similar to the other states, but also an access right, whereby consumers can access to learn more about the type of AI tool used by the business. Next slide. Now, the important thing is the effective date of these laws. I know we're nearing the end of the year. A lot of people are frantically trying to get in compliance with these privacy laws. As you can see, Virginia's law and also the CPRA in California, they go into effect on January the 1st of next year. And then we have Connecticut and Colorado's law going into effect on July 1st. And then at the end of the year, we have the Utah's privacy law going into effect. Now, what's really challenging for businesses right now is the uncertainty of California's landscape when it comes to privacy laws. California is a bit unique, where a lot of the bread and butter of the privacy requirements are actually captured in the regulations as opposed to the statute itself. So a lot of companies are concerned because right now the first half of the draft regulations are still in flux. We recently got even further modifications to the draft regs on October 17th as part of an agenda item of the California Privacy Protection Agency. And we're anticipating that perhaps they can finalize the first half of the draft regulations by sometime end of November, which will leave companies with about a month to get into compliance for California's law. But that still leaves open the question of the second half of the draft regs, which relate to some of the issues we talked about today, such as automated processing tools and data protection impact assessments and cyber audits. And so it does remain in flux, but the good news is that under California's law, the enforcement date for the law is July 1st of 2023. So hopefully we'll have a lot of the regulations we need for full compliance, at least by the summer of next year. Next slide. So thinking through about compliance, it's definitely a challenge. I think now we have 5 privacy laws in the US. On top of that, you have sector-specific laws. And next year, and probably in 2024, we may see more and more states passing privacy laws. And unless we have a federal law that preempts all these laws, which everybody's hoping for, the odds are that we're going to see a patchwork of privacy law throughout the United States. And so to ensure compliance, we've developed this 6 phases of privacy compliance approach. As much as we would love to take credit for this strategy, the 6 phases approach actually comes from the French Data Protection Authority, the CNIL, which released this 6 phases approach. And the reason why we adopted this also in the US is because after reviewing several Federal Trade Commission consent orders and also interactions with the state AG's offices, we learned that all of the compliance steps that these regulators deal with can be boiled down to these 6 steps. And so step number 1 is just ensuring that you have privacy leadership within the company. For really sophisticated companies that might have a well-developed privacy leadership group, such as a chief privacy officer, a CISO, or a chief compliance officer, that's certainly the ideal. But for other companies that are more mid-size, what's really critical is just to have a privacy champion within the company. The privacy champion may ultimately interact with external consultants or law firms or other companies to provide them assistance with compliance. But there definitely needs to be somebody that's pushing for and ensuring that privacy is at the forefront of the company. Phase 2 involves doing a data inventory, which is essentially mapping out the data flows in your company to have a better understanding about what information you collect, why do you collect it, who do you share it with. so that you can develop the privacy governance documents in your company and comply with these laws. Phase 3 is a gap analysis, where essentially you benchmark your data handling practices with the legal requirements, and you identify the areas in which there is a gap that needs to be closed. And once a gap analysis is prepared, you can ultimately move on to phase 5, which talks about the privacy governance documents you would need to prepare to address those gaps, such as a public-facing privacy policy, an employee notice, job applicant notice, data protection impact assessments, forms for submitting consumer rights requests, and procedures for how to handle them, among other things. But for phase 4, for certain high-risk processing activities identified in phase 2 and phase 3, it's important to prepare a data protection impact assessment to mitigate the risks affiliated with certain collections of sensitive data or profiling or automated tools. And then finally, after you implement the mitigation measures, for phase 6 is the final step. And for phase 6, it's important to prepare an auditable record so that all of your compliance steps can be recorded. I know from handling California Attorney General investigations, demonstrating compliance with these 6 phases and having an auditable record to present to the AG's office definitely goes a long way. And it shows that privacy was not an afterthought, and rather it was something that was well developed even before the investigation started. Next slide. And before I turn it over to Howard, I would like to share the CLE code for today, which is Privacy 25. And with that, I'll turn it over to Howard to cover the federal front.
Thanks, Arsen. Next slide, please. So, just listening to Arsen's presentation and the kind of, while there are a lot of elements that are similar or the same within the various state privacy laws, there are differences between them. And as Arsen mentioned, we anticipate that there will be more states adopting privacy laws in the near future. And so that is really a lot of the impetus for federal legislation. With the increasing number of state privacy laws, industry's been clamoring for Congress to enact federal legislation that preempts the states. But I think the other interesting dynamic at the federal level, and that really has provided greater urgency to privacy legislation, has been from the civil rights and consumer advocacy communities, who have sought federal legislation to seek to address their concerns about the use of algorithms and online tracking that produce discriminatory outcomes. Arsen mentioned a bit about the sort of beginning proliferation of laws at the state level that are beginning to address artificial intelligence and algorithms, and this is really sort of coming to a head at the federal level, where concerns about discriminatory outcomes are driving a desire to have a federal law, governing algorithms. Next slide, please. So, I've been involved in the kind of federal privacy legislative debate for about a decade, and really for about the first kind of 8 years or so, members of Congress didn't really get beyond just kind of the principle stage of what are principles for privacy legislation. They did on the data security side, but not really for privacy legislation. They were having challenges getting their kind of arms around all the various elements of comprehensive privacy legislation, kind of similar to the various elements that Arsen mentioned at the state level. However, at the end of 2019, the dam broke to a certain extent. Senators Wicker and Cantwell, who were respectively at the time the chair and ranking Democrat in the Senate Commerce Committees, introduced competing yet similar comprehensive privacy bills. And at the same time, the leaders of the House Energy and Commerce Committee released a staff discussion draft. Next slide, please. Unfortunately, and again, you think about the timing of when those bills were released was at the end of 2019, and so we had high hopes that we were about to enter a period where privacy legislation was going to be a focus of debate, but the pandemic really slowed these efforts because members of Congress focused on the pandemic-related priorities. However, the members that I just mentioned, so Senators Wicker and Cantwell, and then the leaders of the House Energy and Commerce Committee, Representatives Pallone and McMorris-Rodgers and their staffs, continued to meet and discuss potential compromise on legislation. However, these discussions broke down earlier this year. Next slide, please. So earlier this year, when the kind of what's been called the four corners discussions broke down, Senator Wicker continued to negotiate with Representatives Pallone and McMorris-Rodgers. This was somewhat unprecedented. Usually what you see is either the kind of leaders of each party on the respective committees in that House of Congress negotiate, or maybe the Republicans who are the leaders of their respective committees in their houses, or the Democrats continue to negotiate. But what we ended up having earlier this year is Senator Wicker continued to negotiate with Representatives Pallone and McMorris-Rodgers. And these discussions produced the release of a bill, the American Data Privacy and Protection Act, in June. And then the House Energy and Commerce Committee, which Chairman Pallone leads and which McMorris-Rodgers is the ranking Republican on, marked up this legislation and reported it to the full House in July. Next slide, please. So I'll go through the kind of key elements of this legislation. As Arsen talked about, data minimization has really become a focus of a lot of privacy legislation. It's a focus in the state laws that Arsen discussed. It's a focus of even just the FTC. If you all saw the Drizzly consent order that the FTC entered into, and that was announced yesterday, that also has data minimization as sort of a core element. There's a big push for data minimization to be kind of a core foundation of privacy laws, and that was also the case in the ADPPA. In addition to data minimization, it's kind of the driving force of legislation, the driving principle. The bill also has a set of prohibited practices, which for which even consent wouldn't permit certain practices, such as sharing of sensitive information and targeted advertising using sensitive information. Now, the bill also contains permissible purposes that ostensibly are exceptions to the data minimization prohibited practices, but that I would say that as the bill currently stands, these permissible purposes aren't sort of broad enough in scope, given how kind of stringent the data minimization and prohibited practices are. Like state laws and other bills, the ADPPA has transparency and consumer choice provisions. It also has access, correction, deletion, and data portability provisions. As mentioned, it also has civil rights and algorithmic bias provisions. These provisions would require sort of assessments on the front end, and really it's the algorithm term is very broadly defined in this bill, and so really like almost any automated process, the use of an automated process, even for what would be eventually a kind of human decision making, would sort of fall under this requirement. And then there are provisions that are specific to minors. So, for example, things like sharing of data for minors and targeted advertising to minors. Next slide, please. There are other elements of this bill. So there are elements governing data brokers, which in this bill are referred to as third-party collecting entities. Such entities have to register with the FTC, and consumers have the ability to kind of preclude these entities from further collecting information about them, and potentially, depending upon how the FTC implemented this provision, deleting information that these entities have about consumers. The bill also has data security requirements. I would consider the data security requirements fairly, kind of common. I mean, there's nothing really novel in them. It's your sort of typical administrative, technical, physical safeguards, depending upon the type of information, size of the company. The bill also has provisions governing sort of sharing of consumer data with service providers and with third parties. Sharing with service providers is given a lot more latitude than sharing with third parties, but also very limited to, with respect to service providers, a service provider engaging in some processing activity on behalf of a covered entity. Next slide, please. So in terms of enforcement of this bill, the FTC would have primary enforcement authority. State attorneys general would have the authority to enforce the state law, the federal law, which is, while on its face like a little unique, you actually see this more and more in kind of FTC consumer-facing statutes. CAPA is one example, but there are a number of others where state AGs are given an enforcement role for a federal bill. This bill also has private rights of action that involve remedies beyond, sort of financial remedies beyond just injunctive relief, and financial remedies that also go beyond just actual harm. Then, again, getting back to what Arsen said about the various state laws and the patchwork that's created, the ADPPA also addresses the relationship between this new federal law and state laws. It has an overarching state preemption that I think most people consider to be pretty good and pretty sweeping in terms of comprehensive state privacy laws. However, there are 16 or 17 exceptions to the state preemption for various types of state laws that create a pretty high degree of uncertainty with respect to what the really kind of reach of state preemption is. Next slide, please. So the key areas of contention, as I just mentioned, state preemption. On the sort of business community side, there's concern preemption doesn't go far enough. Also, the state of California and some other AGs have expressed a lot of concerns that state preemption goes too far and that states should be permitted to go beyond the federal law. Existing state laws should stand, future state laws should be permissible. So there's still quite a tug of war as to whether or not the bill kind of hits the right mark on state preemption. Private rights of action is something the business community has, historically been very concerned about. And, I think kind of front of mind, as Arsen mentioned, BIPA, the Illinois Biometric Law, has been a source of a lot of litigation. And I think that there's concern that putting a private right of action, especially one that goes beyond actual damages, would create sort of a proliferation of suits, even ones that lack merit. As I mentioned, this bill's kind of overarching principle is data minimization, as well as just flat out prohibiting certain practices, not even allowing consent for those practices. The kind of key exemptions to those overarching principles are these sort of permissible purposes for business operations. These are things like fraud prevention, identity verification, billing, network management, repair, various things that, your companies do in just the normal course of business of, fulfilling a product or service, and, just kind of, running your various sort of back office operations. And then algorithmic bias, I mean, what I would say is there's a lot of passion on this issue. There's a lot of concern about whether or not the right controls are in place in the online ecosystem to prevent discriminatory outcomes. At the same time, the use of algorithms and artificial intelligence is still a very fast-moving area. And there are concerns that legislating in this area now will kind of stifle innovation and the use of artificial intelligence. Next slide, please. And so once again, this is the CLE code. And at this point, we've got, I believe, about 15 minutes for questions.
Thanks, Howard. I think we have a question in the chat about the use of cookies under the state privacy laws. Happy to answer that question. So basically, I think the thing with cookies is it's not like the GDPR where you technically need a pop-up banner with opt-in consent. Rather, cookies, when they're placed on the browser, when you visit a website, they collect information about your use of the website, and some of the cookies can also be used to track you across multiple websites, not only the website that you're visiting, but also potentially other apps and websites owned by other companies. Whenever you track users across those business websites to non-affiliated business websites for purposes of targeted ads, what you should be aware of is that activity constitutes quote unquote sharing or a sale under California's law. And also under the other state laws, there's a right to opt out of targeted advertising, which is just defined by its name, which is targeted advertising. And so if you do have cookies, I would recommend doing a scan of your website. There's a lot of free tools like Ghostery, for example, where you can just get an idea of what type of cookies you have on your website. But also there's more professional tools offered, for example, by OneTrust, or you can work with a consulting company that might scan your website for cookies and organize them by the type of cookie you have. And if you determine that you have a lot of these sort of tracking cookies that are used for targeted advertising, then you should be aware that you might actually be engaged in sale or sharing of data. That's okay, that's permitted. That's a big misnomer that you can't be a seller of data. I think the key thing is that if you are a seller of data or sharer of data under California's law or these other state laws, you just have to make sure you implement the compliance steps, which includes offering an opt-out. And so I have a lot of conversations with clients about this issue. And the key thing is that just to be honest with your practices, if you're going to have cookies on your website, just make sure you implement the compliance protocols for opting out of sale. Now, the one thing I want to put a little caveat to this is if the only type of cookies you have on your website are mostly for functionality purposes, those are typically not in scope. But for any cookie provider you use for more functionality and performance uses, even for analytics purposes where they just give you insights as to who's using your website, make sure you have a service provider agreement with those parties, because that is an exception to sale. If you designate your vendor or service provider or cookie provider as your service provider under the law.
So we got another question. We got a question. How will the new safeguards rule that is going into effect affect some of these rules that were discussed during the session? And that's a good question. It also is going to bring up the commercial surveillance ANPR. What I would say in general is a new federal privacy law is going to sort of trump any sort of rules that come into effect, any existing FTC rules and any rules that come into effect here between now and when legislation's enacted. Now, for the safeguards rule, there is, for GLBA regulated companies, there's a provision in the ADPPA that ostensibly allows GLBA regulated entities to continue to be regulated just under GLBA, but there's some ambiguity that I know a lot of GLBA entities are concerned about, that it's not clear whether or not you can sort of pick one or the other, or whether you actually have to face both. But I want to use this opportunity to also mention, you know, as many of you probably know, the FTC in August kicked off what it's calling its sort of commercial surveillance advance notice of proposed rulemaking. And it's a very comprehensive, I mean, what it terms as commercial surveillance is basically any kind of collection, use, sharing, any kind of activity. And the comments were originally due in that proceeding October 21st. That got kicked back to November 21st. But the problem with that is that, you know, that in and of itself, like if that goes into effect and then legislation comes in, that's just a set of rules the companies are going to have to come into compliance with, and then they're going to have to get taken down as the FTC implements a new law. I'll also point out the concern about that rulemaking is that rulemaking wouldn't preempt all the state laws that arson went through. Essentially, a rulemaking from the FTC like this would likely just layer on top of all of those state laws, just adding to the patchwork.
And Howard, it looks like there's a question in the box, and this is a question you probably get asked 100 times a day, which is, what is the forecast out there about the federal law passing?
So I'll start by saying we've gotten further with federal legislation this year than we ever have. I mean, you had one of the two committees of jurisdiction, the House Committee of Jurisdiction, pass comprehensive federal privacy legislation 53-2, with strong bipartisan support. That said, because of where the state of California is on the bill, with Speaker Pelosi being from California and being close to the governor, I don't see that bill moving through the House this year, because there's, you know, kind of serious tension between, if they reduce the amount of state preemption as California's requested, they're going to lose a lot of support, at least among McMorris Rogers and the Republicans who supported the bill. And I don't think there's a resolution to that this year. The other problem is, even if the House passes a bill this year, I don't see the Senate acting on privacy legislation this year. So I think that, you know, it's a long way of saying that kicks it into the next Congress. But again, like, especially in the decade that I've been doing this, where we are in terms of advancing the debate in privacy and how detailed it has become, and I think narrowing of the issues, I think we're a lot closer to privacy legislation than we've ever been, but it's not going to be this year.
Great. And then one other question I get asked often, and I saw a question in the chat about this, is the issue about human resources data and B2B data. Just one note of caution. Under the CCPA, there was a limited exemption for B2B and human resources data. Essentially, for employee and job applicants, all you have to do was just give a short privacy notice under the CCPA stating what information you collect from them and why you collect it. And there was a broader exemption for B2B data, where essentially you just have to ensure that you safeguard B2B information from a data breach. Those exemptions are actually phasing out end of the year. So HR data and B2B data are going to be fully in scope in California starting January 1st. Another thing, though, which is favorable, is that the 4 other state laws do not include B2B and HR data within their scope. And so when it comes to human resources data or B2B data, your primary compliance obligation is in California. Now, at that juncture, companies have a decision to make. Some, and this is a minority view from just benchmarking I've done, are planning on extending and providing a comprehensive privacy notice for all of their employees throughout the United States, and extending the CPRA rights to those employees. But the majority position I've seen a lot of companies take is, because California is the only state with this comprehensive privacy law that governs HR and B2B data, they're going to primarily extend these rights, especially for employees and job applicants, only to California employees and applicants, in order to minimize their data privacy compliance obligations. And the reason for that is because in the employment context, there could be a lot of contentious issues where an employee who is disgruntled may want to engage in a fishing expedition prior to termination and prior to filing a wrongful termination lawsuit. And so they may submit an access request, or they may request to have their information deleted or corrected to present their file in a more favorable way in anticipation of a lawsuit. So there's a lot of tricky issues, something that you should not only talk to your privacy attorneys, but also your employment counsel to make sure that you address all of these issues. Yeah, let us know if you have any other questions. Great. Well, if there are no more questions, we want to thank you for your time and for joining our presentation today. We're certainly available after this presentation if you have any questions, but we hope you enjoyed the talk today, and definitely some exciting times ahead. Thank you.
Thanks, everybody.